everybody, welcome back to my YouTube channel. I remain Chioma Onuchuku. So today we're going to be talking about wills. First thing that comes into your mind when you hear the word will is, but that is not necessarily the case. Okay, that should not really be the case. Okay, having a will has a lot of advantages, and one of those advantages is that even at death you have control over what happens to your property. Okay, so when I mean control, I don't mean
follow me now.
Jesus Christ, the blood of Jesus Christ, Jesus Christ.
But majorly control over what happens or how your property or your asset or your estate is distributed. Okay? Another important of having a will is to prevent a lot of stress, okay, on the part of your beloved one, because when the person dies without a will, the family or the loved ones have to go through a lot, okay, just to get authority to become to get letter of authorization or letter of administration, as it were. So, and that one is a whole long process entirely. Okay, so I know you would not want to put anybody, or nobody wants to put his or her family through all those hassle. Okay, then another advantage is the fact that you have the right, or you reserve the authority to state what happens to you. Okay, you can decide what, oh, I want to wear a green and a black when I die. I want to, when you're getting bury me in the moon, bury me in the sun, bury me here, there. You get, so you can make different wishes. Okay, you can make different opinions when you write a will. So you see, it's not really that bad. Okay, just you putting your house in order, okay, so that in the eventuality or in the event that anything happens to somebody, which we pray will not, everything is in order, so you are prepared. Do you get? So every member of your family is taken care of. Nobody is coming in interfere with your property or your house or your household, as it were. So majorly it's just to put your house in order for eventualities. Okay, but it's not necessarily meaning doom. It doesn't spell doom. Okay, so please, I want you to get that off your mind. Like, remove that notion. Okay, will doesn't necessarily have to mean you are dying. Okay, it doesn't necessarily have to be that. It's just you making or doing due diligence in event that anything happens. Okay, so how does this will thing work? Like, how does it work? And if a person dies without making a will, what happens? A will can mean two different things. Okay, a will can mean your wishes, okay, your intention, your desire, your expression. Okay, that could be one meaning of a will. A will can also mean a document. It contains what a person wants to happen in the event of death, okay, especially with respect to property. So will can be the wishes or the expression itself, and it can still be a document in itself. Okay, so those are the two different meanings of a will. So a person making a will is called a testator. Okay, so if you are making a will, you are called a testator. Now, if a person dies with leaving a will behind, okay, so if you have if a person wrote a will or left a will behind in the event of the death, you say that the person died testate. Why, if a person dies without a will, you said the person died intestate. Okay, I just want to bring out that difference. Okay, there's a testate and there's intestate. Testate, the person died leaving a will. Intestate, the person died without leaving a will. How do we make a will? Okay, you can make a will personally. Okay, so you can just sit and write and start. You can make your will personally. You can write what you want, you can express your desire. However, it is always preferred, and I will advise, okay, even though I don't advise naturally on this channel, but I will advise you make a will in the presence or with the supervision of a lawyer. Now, why do I say that? Now, there are some, as we shall soon see, there are some technicalities, there are some limitations, there are some restrictions, there are basically some things that you have to watch out for. Else, in the event of the person dying, those things will just act as if you did not actually make a will. So it's as good as you didn't make a will in the first place. So the lawyer is there to ensure that those technicalities, those limitations, those things that will actually invalidate your will and will actually be curbed. What I'm saying in essence is that you can make your will, but it is always advised that you make it in the supervision or under the supervision of a lawyer. The general rule with respect to will, okay, there are some exceptions or some persons that are exempted from it. Military men, maritime or seamen, and crew members, they are actually exempted from the general rule of a will. I just said I should state this out. Let's talk about when a person dies. Testate. Okay, testate. Remember what I told you about testate? The person died leaving a will. Now when you die testate, it means that you've left a will, like I said. So under a testate, basically, or under the will, you are appointing persons that will administer your estate. Now when you do that, those people are called administrators or executors. So basically, you making a will basically give you the right, or give you that freedom, or give you the liberty, or give you the power as it is to appoint persons who will administer, or let me use the word, distribute your estate or your property when the person dies. Okay, so those persons that you choose or you appoint under your will to distribute or to administer your estate are going to be called executors or administrators. Okay, you can appoint one or more executors or administrators. However, the danger in appointing one is in the event that that person is not available, there is going to be a lot of hassle when it comes to administering the person's or the testator's will. So it is always wise and preferable and advisable to appoint more than one executor or administrator. Now, another thing you must put in mind when appointing an executor or an administrator is the fact that if you appoint more than 4, what usually happens is that the law or the people that are going to be selected, because they actually have to I will talk about that later, but when you go and apply for probate, they give to the first 4 people. Okay, so if you are actually appointing more than 4, they use the first 4 people. So when in your will you are stating I want A, B, C, D, E, F, G, and you trust E more, okay, or you want E to be one of the persons, like you trust E more, or E is one of your major persons, don't go and say I appoint A, B, C, D, E, F, G. You can do A, E, C, D, you get, and the others. That's way when they are actually granting probate, E will be part of the first 4 people that will be granted probate. Now if anything should happen to A, for example, so it's remaining E, C, D, right? In the scenario I gave, E, C, D. Now what will happen is that F will be the next. So it has to be, the number of persons that they grant the probate has to be like in accordance with the way it was stated. So if you are stating, okay, dear testator, make sure that it is according to the people you trust. Okay, so don't just say anyhow I state it is fine. No, okay, so it's the first 4 people that actually will be granted probate, and then if anything happens to any of those first 4, the next people will follow. Now if you've been appointed as an administrator under a will, you have to get probate. You have to get probate. You cannot just say yes, I was appointed because my name is there, therefore I shall administer. No, okay, if not, you will be seen as a son taught. Let's talk about intestate now. So like I said, intestate is when a person dies without making or leaving a will behind. Okay, so what happens is that the person's customary law will apply. However, I must state that if a person marries under the acts, what we colloquially call a white wedding, okay, where you are given a certificate, usually the form E, and so basically where you are married under that particular order, or where you are married under the act, the estate law in your state will apply. The estate law in place you've stayed for a while as at the death of the testator is what is going to apply. So let me come over that again. So if a person dies intestate, ordinarily the person's custom would apply, okay, and you do not want to leave that, okay, because you may not know some laws or customs that may actually affect or that may actually be against your loved ones. So most of the times what they say or what the law has said is that when a person is married under the act, the estate law of the state which the person lived before his or her death will apply. Under that law of your state, usually there is a hierarchy of people who are supposed to apply for letter of administration. Now, if you remember vividly what I said earlier, for somebody that died tested, the executors, they ask for probate. Okay, but for this one, this time around, what the persons do is they apply for letter of administration, okay, as different from probate. Probate is where there is a will, but if there's no will, usually you apply for a letter of administration. State laws in states have actually stated a hierarchy of people, okay, who can apply for letters of administration. Now, usually it starts with your spouse. Okay, so if there is no spouse, the children. If there is no children, the parents of the deceased, either the father or mother, whoever is alive. If not the parents, then the siblings. Then if the person does not have a siblings, then the half siblings. Then if there is no half siblings, after the half siblings, you have the grandparents. After the grandparents, you have the uncles and the aunties. After the uncles and the aunties, surprisingly, is your creditors. Yes, your creditors. So you see why you need to actually make a will, so you don't leave things to chance. Okay, so apparently your creditors, people you are owing, can actually apply for letter of administration. And then the last on the hierarchy is the administrator general. Usually the administrator general is appointed by the court, is a staff of the court. And so if all those hierarchy of persons are not, or let's say somebody that is just, a John Doe or a Jane Doe, as it were, and nobody knows anything about the person, or the person just is estranged from family or whatever, for some reason those hierarchy of persons are not found, the administrator general is the one that will get a letter of administration. So as usual, if you are among the hierarchy, so like the spouse or the children, you just apply for letter of administration and you meet a lawyer. Basically, like I said, I wouldn't want to belabor you with all those procedures, but you meet a lawyer and then he would direct you on what to, he or she, okay, female lawyers too, they can direct you on what to do. Anybody can make a will. Even a blind person can make a will. Aside the fact that I said that anybody can make a will, you have to be of legal capacity. Now, capacity can be of age. And in Nigeria, the legal age is 18, although in some laws, okay, in some estate laws in some states, it is 21, but usually it is 18, okay, so you have to be of legal capacity. Another angle or ambit of capacity is the fact that you have to be mentally capable, okay. Have that kind of situation where the person, sometimes he's sane, sometimes he or she is not sane, okay. The testator can be he or she, so sometimes he or she is sane, sometimes he or she is not sane. Usually you would try and get a medical report or a certificate that the person is of sound mind as at the time he or she was making the will, okay. So you don't just leave that to chance, because somebody can just tell you, I'm contesting this will, this person has known to be of unsound mind, so relevant time is at the time of making the will. So if A has been mad for a while and for some reason he gets cured, which thankfully is not for some reason, thankfully he gets cured, and later on he makes a will, the relevant time or the material time will be when he made the will. The fact they won't have recourse to the fact that he has been mad before, but is it at the time of making a will? Was he sound? Was he okay? Now, validity of a will. What makes a will valid? Number one, it has to be in writing, apparently, okay. So if you are making a formal will, it has to be in writing. You have to have capacity, like I said, okay. You must be capable as of age and of mind. It must be attested, so you must have witnesses, okay, that can testify that yes, indeed you made this will when you were sound. So those are majorly the things that can validate or will be the major ingredients in a will. So when you make the will, where do you keep it? Okay, where can you keep a will? You can keep a will anywhere so long it is safe. You can leave it with your lawyer, you can leave it in your deposit box in the bank, you can leave it in the registry, you can just anywhere that is safe is where you keep a will, okay. But it should be where your administrators are aware of. Don't go and put it in somewhere that they can't even access or they don't even know about, because what would basically happen is that it's as good as you did not make a will. So basically your administrator must know about it, and then it is somewhere that is safe. Continue, guys. Please, I don't know why you have not subscribed yet. Like, why have you not subscribed? Just tell me, is there a problem? Is there something I'm not doing right? Okay, so please do well to subscribe to this channel, The Virtual Lawyer. Okay, if you're watching on YouTube, please quickly click on the subscribe button. But if you're not watching on YouTube, please follow me on my page. I'm at the_virtual lawyer. Okay, I post a lot of legal tips there, so you would it's really helpful. Okay, and I really want you to avail yourself of those tips or of those information. So please do well to follow me at the_virtual lawyer. So let's continue with our discussion. Let's talk about 5 things you must do or you must avoid when making a will. But 1, never make your terms vague. Don't leave your terms vague. Okay, I gift a house to ABC. Okay, so a house, maybe what if you have like 6 houses, which one? So you have to be very detailed in your terms. I am giving the house at Ikoyi, I am giving the house at VGC, I'm giving the house at this painted red. You have to be very detailed about the terms of your will. Okay, so if you are gifting anybody, it should be a detailed term, it should be a detailed gift. Okay, don't just leave it vague. Number 2 is the fact that if you've made a will already and let's say subsequently you acquire other assets, ensure you update your will, because if you just leave it to the past will or the former will, what happens is that those other assets you've acquired will be left hanging, and what usually applies is different, is something different entirely, so it will fall under the residual properties or residual gifts. Okay, so you would ordinarily want to give to a person, a particular person, or their pet, as it were. Okay, so when you get assets or when you keep getting assets, you keep updating your will so long the former one is destroyed. So when you make a new one, you destroy the old one, or you make a codicil. Okay, a subsequent will is called a codicil. So you have the main will and then the subsequent ones are now called a codicil. So it's either you destroy it or you make a codicil. The 3rd thing is to allow the wrong person to actually be a witness in your will. So there are some certain persons that cannot actually attest or be witnesses to a will, and one of such person is your spouse. Okay, so your spouse cannot witness your will. Another person is a beneficiary. If you know that you're going to gift somebody something under your will, that person cannot be a witness on that will. So if you feel, so don't feel like this person has called me to witness his will. There's not what that ordinarily means legally. What that means, the implication of that is that you are not getting anything from that will. So if you are a beneficiary, you cannot sign a will. So when you start signing a will, just know that another thing is the fact that if you are gifting a child, if you are gifting your child below the age of 18 under your will, ensure that you actually put a guardian over that property. Okay, so you can say, I'm gifting A, who is 13 years old, my house in Ikoyi, but I'm putting BCD, my wife, as a guardian, subject to when he or she attains majority. Okay, attains 18 or 21 or 24. Okay, so don't just leave your will, especially for when you're leaving it for a minor. Okay, make sure that you appoint a guardian over that will or over that property, and then ensure that you sign. Okay, ensure that you sign. Make sure that you do not leave your will unsigned. Okay, sign your will and make sure that it is attested to by the in presence of the witnesses. Okay, don't do it like I signed today, then tomorrow my witnesses will come. No, that will be held invalid. Okay, it cannot operate. So your witnesses must be there, maybe not together, but a witness must be there when you are signing the will. Okay, and the signature must come for the attestation. Okay, so don't go and get your witnesses first before you sign. No. Okay, make sure that you sign and preferably put a date before the witnesses come and sign and attest to your will. So let's talk about limitations of a will. Are there anything, is there anything that is restricting you from making your will or expressing your freedom or your expressions? That's what we're going to be talking about now. And yes, there are some things that are actually going to limit your testamentary freedom. Okay, they call it testamentary freedom. So a testamentary freedom basically is saying that the testator has the free will to distribute his property anyhow he or she likes. Okay, but there are some things that are limiting you, and one of that is a reasonable financial provision for maintenance. So don't feel like I am going to gift all my property to my sugar girl leaving your wife and your children behind. No, okay? So in such a situation, the court will look at the scenario or the situation, and since there's no reasonable financial provision provided for them, your wife and your kids can actually go to and approach the court and ask for reasonable financial provision, okay, to show that yes, we had actually been sustaining ourselves through our husband, but fortunately and unfortunately he didn't leave anything for us, so we are applying for reasonable financial provision for maintenance, okay? So it doesn't have to be for luxury, it's just basically to maintain them, and this must be done within 6 months. So if you are going to apply for a reasonable financial provision under a will, it must be done within 6 months after probate has been granted to the executors, okay? That thing is customary law, okay? There are some customary laws that you cannot just do without, or you cannot just do away with, and one of that is the igiogbe under the Benin law and custom. The igiogbe is just a classic example, okay? So you cannot give your igiogbe to your last son when your first son is still alive and functioning very well, okay? No, okay? So there are some customs that you cannot just do away with, so long it is in order with natural justice, equity, and good conscience. The restriction is the fact that if you are under, or if you are subject to Islamic law, so these are for my Muslim brothers and sisters, so you cannot just dispose or distribute your assets or your property, okay? So a Muslim and you are making a will, as at the time of your death and you're still a Muslim, your Muslim law will apply, and not your will, as it were, or not your will, not your custom, but your Islamic law. Qualities of an administrator. What are the qualities you should see in an administrator before appointing one? It is very important, and one of them is willingness, okay? You must choose somebody that is willing to be an administrator. Don't go and choose somebody that don't like stress, and then you're appointing the person and the person is like,
leave me alone, please leave me alone, leave me alone, please leave me alone.
Especially if that is the only administrator you choose. I mean, that is total chaos, okay? So you must appoint or choose a person that is willing. You must choose a person that doesn't have conflict of interest, okay? So you see this person, you know this person always had eye for your car, and you still went to appoint this person, or the person is your spouse, or the person basically has a conflict of interest with respect to your property. Ensure you don't just leave the person out of it, not out of malice, but so that equity, good conscience, and your property will be distributed without fear or favor, okay? Another thing is the fact that if you are appointing an administrator or a person, it should preferably be a younger person. So the usual phase of life is that the older dies before the younger, okay? So it is always right, or it is preferable you use a younger person with the mindset that yes, in case the disease goes, the person is a younger person, so the person will be alive. Another thing is the fact that you must choose, or you should choose, or it is preferable you choose somebody that will be available, okay? Not somebody that is abroad, okay, or except the person can probably come here, okay, and act in his or her capacity as an administrator. You should choose somebody that is available. Appointing more than one person, okay, it should be somebody that can work with a team. There are some people that are like, I'm an island, you can't tell me shit, I do this. Some people that are authoritative, they can't work with people. It is a red, not like a red flag, but then it is always preferable you choose somebody that can work in a team, especially when you are choosing or you are appointing more than one administrator. That is it, guys. Thank you very much for watching to the end of this video. I hope you learned something. Please do well to leave your comments and your questions on the comment section, and I will reply. So please don't forget to subscribe to my YouTube channel if you've not done that. So quickly click on the subscribe button, and then follow me on Instagram at _virtual lawyer, okay? That is where I drop a lot of legal tips, and I really want you to avail yourself to that platform, okay? So thank you very much for watching, guys. I look forward to seeing you once again. Bye, guys. Or you are involved in the marine world, if you're involved in the